Okay.
And I am going to share my screen.
Right.
How's that?
Looks good to me. Okay. Well, good morning, everyone. Thanks for joining us. We like to do these kind of refreshers, particularly on open meeting, conflict, and public records law, every once in a while. That's something that all town officials and employees have to deal with to some level or another. We're just doing open meeting and conflicts this morning. Open meeting has a little more to it, so I want to start with that one. And so we're just going to go through these slides, and I'll talk about them. And as Maureen said, if you have a question or a comment or a war story or anything like that, feel free to use the raise hand button, and we'll stop and do that. All right. Okay. You all set, Maureen? Okay. Just this is our legal disclaimer. But just so you know, with both of these laws, I'm doing sort of a broad brush, nuts and bolts approach. What the answer might be in a given situation often depends on the specific facts. But hopefully, you'll take something away from this just based on the kind of going over the basics. Okay. So these are two out of the three sunshine laws, the other one being public records. Basically, every state has them. It's so that the general public is aware and can follow along if they choose with what's going on in their local government. And it does tend to make things challenging for those of you in town government. But that's the reason these are there. And so we all have to do the best we can with them. Do we need that thing on the side, Maureen, the right-hand side? Sort of a preview, but it wasn't on last night.
Maureen, if you have two screens, just share the other screen.
Well, that'll work too. We don't necessarily need the one on the left-hand column either. Okay. So this is the open meeting law. It's found in chapter 30A of the general laws. And I'm just going to go over the basics of, which meetings, which groups are subject to this. Just as an example, town meeting, open meeting law does not apply to. No part of it does. What the basic rules are and what tends to pop up as common violations and how to avoid them. Okay.
I think you're on mute.
I think Maureen's trying to get the screen look better. Okay, that's the way we had it last night. Yeah, good with you, Maureen? Hmm.
Maureen, you're muted. We can't hear you.
I think she's just trying to get the screen sharing thing to be in the right place.
Well, her mute button has a red line through it.
It is, yeah, you're right.
Maureen's not trying to talk to anybody. She was talking to me.
Okay.
Thank you, Erica.
We'll get this squared away and then proceed.
It's still not screen sharing. You want to forward it to me?
Okay. That looks good to me.
I don't know what's going on, but we don't know what it is.
All right, I'll proceed, Maureen. You let me know if you still have any issues here. So the open meeting law has certain definitions that are right in the statute. The more obvious one is meeting, which is a deliberation amongst a quorum of a public body to discuss matters within the jurisdiction of that body. Obviously, if you're talking about the weather, you're not discussing a matter within your jurisdiction. So strictly speaking, that's not a violation. Quorum is important to remember too. So if you are a 5-member body and 2 of you happen to run into each other outside of a meeting and you start talking about, let's say, an application that's pending before your board, is that a violation? Well, it's not, because it's only a violation if there's a quorum involved and it's not at a posted meeting. So you don't need to worry about that. If a 3rd member out of the 5-member board shows up, all of a sudden you do have a quorum, and so then you're not supposed to be having that kind of conversation. Deliberation is any oral or written communication through email. I'll talk a little bit about email, which is a very handy tool, but also tends to lead to open meeting law violations inadvertently. Quorum typically is a majority of the full members of the body. There are some exceptions, like a zoning board to grant a special permit requires 4 votes in favor. So we kind of look at 4 as the quorum. But in general, it's just a simple majority. And public body, you'll see, is a very broadly defined any board, commission, committee, or subcommittee within the town, whether it's elected, appointed, or otherwise, could be temporary. If it's there to serve a public purpose, as part of the town government, you should consider that it's going to be subject to the open meeting law. Okay. Okay, great. So it does include subcommittees. And so this clearly applies when a public body decides it wants a subcommittee, a smaller group, to go look into something and bring a report back so the entire body can act on it. If it's sort of set up formally like that, maybe the chair or the body votes to set up a subcommittee and says who's going to be on it. That subcommittee is also going to be subject to the open meeting law, meaning posting your meetings, taking minutes, all that stuff. And it can apply if it's a little less formal than that. But just as an example, say, again, a 5-member body, 2 of the members talk to each other and say, well, why don't we dig through this consultant report or whatever it might be. And then at our meeting, when we actually have one, we can, pass along our conclusions. That's fine. I would say that's not a subcommittee. It wasn't really designated to do anything. It kind of came together organically. There wasn't a quorum involved. So I'd say that those two people are not really a subcommittee. They're kind of doing it on their own. Also, one person is never a subcommittee. There's always has to be at least two. And but if it's, if you're not sure, or if you think perhaps you're going to fall under subcommittee, the safest thing to do is act as though you are and post your meetings and keep minutes. The court case at the bottom concerned I believe, if I'm recalling this right, a superintendent of schools who needed to look for a new principal. And it was the superintendent's job to do it. He decided that he wanted sort of a search committee to assist with that, and appointed one. And someone complained that they hadn't followed the open meeting law. But what the court said was that this was not a subcommittee or a public body of the town. It was just a body of the superintendent who could have done this all by himself. So that's a sort of interesting loophole, if you will. But the Attorney General, who oversees the open meeting law, follows this as well. Okay. So briefly, there's kind of four major things that the open meeting law governs. One is your meeting notice, typically referred to as an agenda, but the statute uses the terms notice. So you need to post it in time, no less than 48 weekday hours. That's excluding weekends and legal holidays. The location must be somewhere where it's accessible 24 hours a day. 20, 25 years ago, that meant posting it on a bulletin board outside of town hall. Nowadays, most towns have adopted the town website as their official posting location, as has Nantucket. And so obviously that meets the 24 hours a day requirement as well. And the notice must have a detailed subject, a list of the things that are going to be talked about or anticipated to be talked about, with enough detail there so someone looking at this notice can understand what each of those matters is, and they can decide if they want to tune in or show up. The nature of the meeting, typically they're in open session. There are some ability to go into executive session, which means the public is excluded, but there are a number of rules about that, which I'll touch on. How the meeting is conducted differs between a meeting and a hearing. A hearing typically means that either an applicant for a license or perhaps abutters are have given special notice, and so typically they will be allowed to address the board, whereas a public meeting, that's not necessarily the case. So I'll talk a little more about that. Deciding who gets to speak and when, that kind of falls to the chair. And at the end, I'll touch a little bit about remote and hybrid meetings. These are the law changes that happened when COVID hit, and they are still in place for about another year and a half. And then minutes have to have enough detail so someone who wasn't there can follow it. There's a limits on how much time you have to prepare and finalize those minutes, and decide how to approve it, whether it's the whole board voting on them. You're going to designate the chair or somebody else to be in charge of minutes. And I'll talk a little bit about executive session minutes and when those have to become public, if at all. Okay. So as I say, basically all meetings, I'll refer once to emergency meetings, which don't come up much. 48 weekday hours. Must have all the topics which the chair reasonably anticipates will be addressed. And even if a meeting wasn't posted correctly, if a quorum was there and they're talking about matters that are before them, that is considered a meeting. And if you didn't post in time, that means it's a violation. And I'll talk a little bit about what to do if you find that happens. And quorums in person, obviously that means 3 people in the same room. But of course, with email, you can have 2 people emailing back and forth, and then a week later, it gets forwarded to a 3rd member. All of a sudden, you have a problem. Okay. So the statute it defines meeting, and then it has these 4 exceptions, meaning these things are not considered a meeting, and therefore, even if you have a quorum there, it's not a violation. The first one is kind of tailored towards email, distributing, by one member, whether it's the chair or maybe a staff member, distributing something to the entire body. The meeting agenda, that's very administrative, not really deliberation. So that's except scheduling. Let's say the chair says, it looks like we're not going to have a quorum on Monday. Can people make it on Wednesday or Thursday? And you have emails back and forth. Again, that's just an administrative thing. So that is permitted. And then circulating any documents that are going to be discussed at the next meeting, as long as none of the members are expressing an opinion or ideas to a quorum of the body. So if the chair sends an email and says, we got our consultant report back, here it is, please review it and we'll talk about it on Monday, that's fine. If the chair goes on to say, pay strict attention to section 2 because I disagree with our consultant's opinion and here's why, that you're not allowed to do. That's the kind of statement and discussion that is supposed to happen at a posted meeting so the public gets a chance to listen as well. On-site inspections are not considered a meeting. So if you are a particularly useful for a land use board, conservation commission, zoning, planning, you might be asked to do something concerning a piece of private property. The whole board can go and walk around, ask some questions of the owner or the applicant. And that is all fine as long as you then don't stand around and start talking about the merits of what you're being asked to do. That all has to be held until you have a posted meeting. If it's some sort of private event, social event, you're there, it's a birthday party or a holiday party or something along those lines, it's not a violation to have the whole board there. The violation is if you go huddle in the corner and start talking about board business. So that's fairly straightforward. Kind of similar, if one board has a posted meeting and another board is interested in it, or maybe they're going to have to deal with it next, they may want to go sit in the audience at that meeting and perhaps participate, get up and make a comment. That's fine. Again, if you're not all sitting together and talking to each other about it, then you're not in violation. And it's good to kind of say, well, I'm on the planning board, but I'm just I'm only speaking for myself about this matter. That'll help avoid it even looking like a problem. Okay. Some tips. So as I mentioned, just be careful about being all together at some event that is otherwise not considered a meeting. Again, if you're talking about the weather, not a problem, but some people may see you, a quorum of your board, talking and wonder what you're talking about. So same with the site. Let's say you're doing a site visit and you think you'd like your board to actually talk immediately about what you just saw. Well, if the site visit's at 4, maybe schedule a meeting at 5. So then you can go have your discussion in public while everything's fresh. As I mentioned, if you're at a different board's posted meeting, should make it clear that you're speaking for yourself and not on behalf of your board. And joint meetings can be useful as well. Let's say the select board and the finance committee wants to meet before town meeting to go over budget. In that case, both boards are really acting within their jurisdiction, so it's best to have both of them post a meeting, whether it says joint agenda or what have you. Both boards are responsible for posting and taking minutes at those. Okay. This, as I say, email can lead to inadvertent issues. So if there's an email that goes out, let's say, either some draft minutes or a report for the next meeting, just be careful if you hit that reply all button, because if you're expressing opinion, all of a sudden that's an issue. Try to limit the use of email for board to the scheduling or just, reviewing the agenda, kinds of things. And email can always get forwarded to someone you weren't thinking of, so that can lead to issues. And basically just, don't put in your opinions about things. Just say, I'd like us to discuss this at the next meeting, and hold your, discussion points about it until you're actually at the meeting. That way you avoid any violation. Okay. And the same thing applies to social media. If a board member posts something on their Facebook page, and then another board member makes a comment on it, and then another one joins in, all of a sudden it's similar to email, except that everybody can see it. So same idea. Keep your comments for the public meeting, and you will hopefully avoid problems with that. I guess I need to change the Twitter symbol to X. Haven't got around to that yet. Okay. So before the meeting, so it has to be posted 48 hours ahead. Typically, and I believe that's the case with Nantucket, it goes through the town clerk's office that's responsible for making that posting on the website. It's important that everybody gets those notices to the clerk's office on time. So let's say you're meeting at 7 o'clock on Monday night, it has to be posted before 7 o'clock on Thursday night. So if you get your notice in on Thursday after the clerk's office has closed for the day, you're not going to get it posted on time. The notice has to include the date, time, and place of the meeting. As I say, a list of the topics that the chair reasonably anticipates will be discussed. That is straight out of the statute. And the topics, this is from an Attorney General regulation. The topics must have sufficient specificity to reasonably advise the public of the issues to be discussed. So you don't want to, just as an example, let's say a board is going to talk about, the upcoming road repairs. The agenda shouldn't just say discuss upcoming road repairs. It should say, discuss upcoming road repairs on, East Main Street and Central Street. So that way there's enough detail where the members of the public can say, oh, well, I go on Main Street all the time, so maybe I'll attend that. Whereas the first one I use doesn't tell anybody anything. Okay. So conducting the meeting. So this one issue, which has been in the news lately, has to do with members of the public being allowed to speak. Now, first off, the open meeting law says that no one shall address a public body unless recognized to do so by the chair. So you do not have to allow the audience to participate. They can be required to just listen. Most boards like to have some sort of a public comment period, or if someone's in the room and raises their hand, recognize them to hear what they have to say. But the open meeting law itself doesn't require that. And so if you're going to have that kind of public, public input section, you want to sort of set it up, be prepared to do it in a consistent manner. The reason it was in the news, you may recall a case that came out from the state Supreme Court late spring, early summer, maybe. And it concerned a public speak period, and somebody got up and was making rude and insulting remarks to the board and got shut down by the chair. And of course, this ended up in court, and the court agreed that is a First Amendment free speech issue. If you're allowing one person to get up and speak about, the topic that's going on, and then the next person come up and is being rude and annoying, you can't shut them down because they have the right to make those kind of comments, for better or worse. That's what the court said. People have a right to be rude. It literally said that. So it's an important issue if you do want to allow public speak, period. Okay. So things to consider if you want to, when are we going to have this? Is this, do we want to start the meeting like this? Do we want to end it? Are we going to recognize people during our discussion about topic A or topic B? How long is this going to be? Is it be the first 10 minutes of the meeting? If somebody wants to get up and speak, do they only get 1 minute, 2 minutes? And if are people going to be permitted to speak more than once? So all sort of, it's kind of good to have at least an informal policy in place that the chair can kind of control what happens to an extent. Okay. So if you do have that kind of rule, it has to be, strictly on process and who participates and how long, et cetera, and not to what they want to talk about. You can have restrictions to an extent. I mean, you can try to say that if you're going to talk on topic A, restrict your comments to topic A. But as I said, based on this court case, you even have to be careful about that if somebody starts being obnoxious, for lack of a better word. And you want to avoid debate during this public comment period. Kind of the best practice is to say, anybody who wants to address the board, here's your chance. And they get up and talk for 2 minutes. If it's something that's on the agenda later, it's okay to say, I'm interrupting you. Can you please hold that when we get to reach that on the agenda? Otherwise, if they're raising matters, you may just want to say, all right, thank you for your comments. Next. You're not required to get into a big debate with anyone or answer their questions, but you can, leave things unresolved. And if it's something that you think the board may actually want to talk about, but it wasn't on the agenda, a best practice is probably to say, thanks for bringing that up. We will put that on our agenda for a future meeting, and that way, everyone gets a chance to know about it. Okay. Minutes are very important. They are a permanent record of the town, and it's important that they get done in a timely manner because people are out there looking to make sure that happens and that they have the right information in it. So obviously date, time, place, the members who are present or absent, a detailed summary of the discussion of each topic. And the idea, again, this is from the Attorney General, is that someone who wasn't at the meeting can look at these minutes and at least get the general idea of what the subject was, what the discussion was about, whether there were any votes, taken, any decisions made have to be on it. Public body can't do secret ballots. So you don't necessarily have to have a roll call unless it's unless in certain circumstances, but you need a record of the votes. And the statute also says the minutes must include a list of documents that were used by the body at the meeting. So those documents are not actually part of the minutes, but they have to be listed. And to fall under that category of what was used means the document was physically there, it was identified in the discussion, and the content was at least generally discussed by the members. If that's the case, that document needs to appear in this list. This is a requirement that has been there. Some boards are better than others at.
Hey guys.
Hello? Okay. So as I say, the list needs to be there. It can be, kind of bullet points. Consultant report from Weston and Sampson, correspondence from school superintendent. It doesn't have to go into what is in the documents. They just have to be listed. So again, if anybody looking at the minutes 6 months later say, oh, I'd like to take a look at that report, they know it's there and they can know where to start looking. Okay. So minutes have to be approved because you want final approved minutes to become the public record. Where's that coming from? And that applies to open and executive session minutes. The Attorney General's regulations say that the final approval must happen within the next 3 meetings or the next 30 days, whichever is later. And so this is a good practice. Before this regulation came in, I'm not sure who's doing that, but maybe you can figure out how to turn it off. You know, you want to get your minutes finalized when everything is still relatively fresh in everyone's mind. Open meeting minutes are public records as soon as they're created. That even applies to drafts. And if someone makes a records request for minutes of a board, those have to either be provided or explain why they're not public within 10 calendar days. That's actually different from the public records law, which applies a 10 business day limit. But this is an exception, which the supervisor of records acknowledges, and it's 10 calendar days for a minutes request. Okay, Maureen, any idea where that came from? All right, well, I'll keep going as long as we can still read. So
I'm gonna
executive
see if I
session
can-
minutes. Oh, okay.
Excuse me, I'm gonna see if I can pull up a clean version
Okay.
of this.
All right, I'll wait. That's a new one on me.
How's that?
Hey, much better. All right, thank you. So executive session minutes. Executive session is where you fall under one of the categories that allows you to have a private meeting, private discussion. And executive session minutes can be withheld if someone requests them until the purpose of the exemption has been met. And so I'll get to that in a second. But also executive session minutes, even if they have to become public, if there are pieces of them that are otherwise exempt under the public records law, those can be withheld. For example, something which qualifies under the attorney-client privilege can be withheld permanently. You may have the executive session may have been about a personnel issue, complaints against a public official. If it falls under the personnel file exemption under the public records law, you can redact that part of it. But in general, you should be aware that executive session minutes are going to become public at some point. The statute says that the chair should review executive session minutes once in a while to make sure that we're not sitting on minutes that really need to be released. You can go into executive session in order to review and approve executive session minutes. Exemption 7 of what's a permitted executive session is where it's provided by some other general law. And the open meeting law itself says you can withhold these things until they have to be produced. So you can go in executive session to review those minutes. As I say, if somebody makes a request for them, you either have to provide them within 10 calendar days or give a reason why it's still exempt from disclosure. Okay. Oh, yes. As you know, in town meeting, if you are going along and it's 11 o'clock at night and everybody decides to adjourn for the night and to come back tomorrow, that's perfectly fine with a town meeting. The open meeting law does not allow that. If you think you want to do that over 2 nights, you need to post both nights at least 48 hours ahead. And there may be other notice requirements, depends on your board perhaps, but some things require notices to abutters to be sent out 7 days ahead. You need to make sure that those get taken care of as well. Okay. Where posted, I talked about this, the town's website is the official posting site. Good things, because the Attorney General has also said this is how it's supposed to go, is using acronyms. The Conservation Commission deals with, applications for a notice of intent. And so they talk about NOIs all the time. But the typical person who doesn't deal with conservation may not have any idea what NOI means. So it really should be spelled out so the public at least understands what that is referring to. Same with abbreviations. State agencies all have their abbreviations or acronyms. Better to spell them out so you figure that people who aren't savvy on that kind of stuff can understand it. You want a record of when the agenda was posted, because people do complain and say this wasn't posted 48 hours ahead. And if it's on the website and you can show that it was posted 50 hours ahead, well, then you're in the clear and you don't have a violation. I'm going to talk about kind of late added things to an agenda. If an agenda is posted once and then it gets revised, you want to make sure there's a record of each one of those. Okay. So the statute says all matters that are reasonably anticipated by the chair must be included on the agenda. And so ideally that all happens 48 hours ahead. If it was not reasonably anticipated by the chair, some new thing comes in the mail, there's a court decision the afternoon of the board meeting and town council wants to come update you on it. Late adding is okay as long as it was not reasonably anticipated. And it is all right. It's the AG says if you can, let's say it's the day before, to the extent possible, you want to update the agenda and give the public as much notice as you can. And it's not a violation for these late added things to be talked about and even, maybe make a decision about it. But the AG does recommend that unless it's something that requires that kind of quick decision, we recommend that you put it off to the next meeting. That way you can have a proper agenda item and the public can see what's going to be talked about. But strictly speaking, it's not a violation, even to have a discussion about something that somebody gets up in the audience and brings up. But if it's something that may have a broader interest, better off to put it off to the next meeting. Okay. This is in the old days, the older open meeting law, a lot of boards would just have these categories to say, well, this is what our agenda is. We're going to talk about new business. We're going to talk about old business. We're going to talk about the DPW superintendent report. The AG doesn't like these. Again, you're supposed to list, if you have 5 things under new business, you're supposed to list them individually. Application for a license for whatever at 15 Central Street. That way the public knows whether they're interested in it or not, but at least they know what's being talked about. Same with old business. We talked last night when we were going through this about if a board has an extensive packet of materials that are available on the website that includes this DPW superintendent report, is it okay to just say DPW superintendent report because the whole thing is there and people who are interested can look it up? The AG, I think, prefers that there's something more than just this little bullet point on there. But I do think it would be all right if it's, let's say it's a 10-page report and you don't want to try to summarize it on your meeting notice itself. Maybe say DPW superintendent report, see attached packet, something like that. So anybody who wants to get an idea of what's in that report can find it. Okay. Emergencies. So an emergency meeting that is provided for in the law, but the Attorney General has an extremely narrow view of what qualifies as an emergency. Obviously, if it's something that the board was supposed to approve, they forgot to get around to it, all of a sudden tomorrow's the last day. If you have to post a meeting and call it an emergency and sign off on this thing, I mean, maybe that's the best way to go, but the AG is likely to say, no, that wasn't really an emergency. And therefore that was a violation, that meeting. The typical ones that are accepted are, public health and safety issues. The example I use is suddenly the meeting, suddenly there's a blizzard scheduled tomorrow, which wasn't happening. Maybe the select board wants to sit down with police and fire and DPW and kind of make sure everybody's ready to go. That's clearly qualifies as an emergency. You didn't know it was coming, that kind of thing. Denise, did you want to make a
Yeah,
comment?
Brian, sorry, on the last slide. So for the finance committee meetings, when we're reviewing all the articles for either our special or annual town meeting, we've always had an agenda item that says we're reviewing articles 1, 2, 3. And then we had an agenda item that said, and any other articles if a citizen shows up and wants to talk about other articles. What I just heard you say is we really shouldn't do that anymore.
Well, no, I don't think so. That's actually something which has come up in particular complaints, and the Attorney General has weighed in on it. I think they're not crazy about review town meeting articles,
Right,
but review town meeting articles, 10 through 18.
correct.
That I think is still okay.
Yeah, we
Perhaps if
post, okay, go
yeah,
ahead. We do
just
post
any-
that. So every every meeting, we do post, at least 3 days ahead. Here's the articles we're reviewing at this particular
Yeah.
session. And we have another agenda item that says any articles for the town meeting in case a sponsor shows up that we didn't know was coming. So we
Yeah.
then discuss their article. But I didn't know if that and any other, the more general one, is that still allowed, or you would suggest? we
It
don't
is
do it?
still allowed because that is aimed at things which the chair in putting this together didn't anticipate, these are articles
Okay.
that weren't anticipated.
Okay,
And so, if that happens and, Article 20, we weren't going to talk about that, but, you're here, so let's talk about it. That's fine. The AG's sort of stock advice is if this is something which would have broader interest to the public, we recommend you put it off till the next meeting. But
Okay.
it's not a violation for you to have that agenda item or to have a discussion.
okay, thanks, Brian. Sorry I was slow to raise my hand. Thank
No
you.
So just in case you have cause for an emergency meeting, post it as soon as you can. Don't talk about other things other than the emergency. You still need to take minutes. And depending on what the subject was, it's probably a good idea for that board at the next regular meeting to say, we held an emergency meeting. Here's why. Here's what was discussed. We're going to approve these minutes and they'll be, available to the public. These don't come up all that often, but it is okay to have one. Recording. So the open meeting law says that if there's going to be a recording at the meeting, the chair should make a public statement regarding that. So anybody who's either sitting there in the room, or if it's a remote meeting, people who might be talking are aware that there's a recording going on. And that applies whether it's, let's say the local cable TV is broadcasting it, that statement should be made. It also applies if somebody in the audience wants to record it. And the statute said that an individual like that is required to inform the chair, and the chair makes this announcement. If somebody wants to set up a video camera, this doesn't really happen so much anymore, but you can say, yeah, you can record this, but you have to be off to the side here. But if it's an open session and somebody says they want to audio or video record it, you can't tell them they're not allowed to, because they are allowed to. And the purpose of the announcement is there is a criminal statute which says it's a crime to record someone without their knowledge. And so that's why this was tucked into the law, to make sure that everybody who's there understands they're being recorded. And so whatever they say or do is going to be preserved. Okay. It's mentioned executive session. There are 10 purposes in the statute which are acceptable for an executive session. So you have to kind of fit yourself into one, otherwise you're not allowed to have a private meeting. If you're going to, you have to convene the meeting in open session and vote to go into executive session. So there's an actual open session record of that. And you're supposed to, both in the agenda and in that vote, you're supposed to state all subjects that may be revealed without compromising the purpose which the executive session was called. As an example, one of the purposes is to discuss litigation strategy if there's a court case going on. Typically, especially if the case is already underway, that's not a secret. You know, people can get access to the court records. And so if you're going to go in and talk about the Smith versus Planning Board case, you should name that case so the public at least knows that's what's being discussed. They can't listen to the discussion, but they're aware of it. And you're not really compromising your, strategy position by listing the case name. So you need to, the chair needs to take a roll call vote to enter executive session. It should be announced if you're going to come back into open session or are you going to terminate the meeting at the end of the executive. Same rules apply for exhibits, the list in the minutes, taking detailed minutes. Don't discuss things that belong in an open session while you're in executive session. It's kind of easy to stray off topic sometimes, but that's not allowed. And all votes within an executive session have to be roll call in the minutes. Okay. As I say, there's 10 purposes. A lot of them are kind of esoteric and really don't come up much. These are the big four that happen on a regular basis. The first one is sort of aimed at an individual, often a town official or employee who may have a complaint brought against them, or it's a disciplinary matter. It doesn't have to be, but any talk about the reputation or physical condition about an individual, rather than professional competence, meaning sort of job performance generally, that can be done in executive session. You don't have to identify who the individual is for privacy reasons. But that if the individual is going to be discussed, you have to give them written notice 48 hours ahead that this is going to take place. You can come, be in the executive session. You can bring a lawyer if you think you need to. But obviously for privacy concerns and personnel issues, that's a perfectly appropriate reason for executive session. Number two is for strategy sessions to prepare to negotiate with a non-union personnel or to actually conduct collective bargaining sessions with either a non-union personnel or a collective bargaining with a union, sitting around the table with the union representatives. That can happen in executive session. Number three is strategy. The board, whether it's the school committee, select board, can talk about what their strategy is for going into the next bargaining session, and same with litigation. If an open meeting may have a detrimental effect on the bargaining or litigating position, and the chair so declares. So when going into executive session for this purpose, the chair should state, we're going in to discuss the Smith versus Planning Board case, and we're doing so because in open session that may have a detrimental effect on our position. That's supposed to be sort of part of the record, part of the vote. And the same applies for matters concerning real estate. If the town is considering a purchase or exchange or what the value of real property is, obviously you may want to talk about that behind closed doors to not let the other party to that transaction know what your opinions are. Again, the chair should declare that in the vote to go in. Okay. Let's see. Just as the vote to go in is supposed to have some details so people understand at least generally what's going to be talked about. Best if that's in the meeting notice itself. And let's see. Yeah, it's kind of along the same lines that if you're going to go in to discuss strategy for a collective bargaining group, you need to list what that group is, so the public is aware. Okay, these are the negotiations that are going to be talked about tonight. Okay, that's kind of repetitive. You can keep going. This brings us to enforcement. So the Attorney General, when the open meeting law was revised about, I think around 14 years ago, the Attorney General was put in charge of it, and there is the Division of Open Government, which is the division of mostly lawyers, not entirely, who are in charge of kind of interpreting and implementing the open meeting law as well as enforcement. So if you sit on a board, you may have received a complaint. The AG has a particular form which is required to be used. People fill out, they explain who they are, what they think the violation was, and what they would like to see happen. If you get one of those, you need to deal with it at a meeting. So it needs to be listed on the meeting notice. Then you want to acknowledge you received this complaint, talk about what the allegations are, a possible resolution, whether you agree that, yes, we did accidentally not post this in time, or maybe you feel that the allegation is incorrect and you did not violate the open meeting law. And then you want to vote to resolve what to do about it, because a written response is required to go out to both the complaining party and to the AG within 14 business days. And a board can delegate. They can say either, here's what we think our response should say. We're going to delegate to the town manager's office to draft and send that out. Often our office, town council, will draft what we think is an appropriate response and send the draft to the board, and they can review it and tweak it and then vote to approve it. And that's the letter that goes out. If you do get a complaint and you realize that indeed you violated, maybe you didn't, you talked about something which was accidentally left off the agenda, or you posted the meeting 12 hours too late. The Attorney General very much appreciates it if a board says, oops, this was a violation, but here's what we're going to do to cure it. So for example, if an email exchange ended up going to a quorum, the board can discuss this when they're dealing with the complaints and say, this wasn't intended, but it did happen. So, here's the gist of what that quote discussion was about. So we're going to go over that in this meeting, and, it may be appropriate to attach the emails to the minutes. And the AG will look at that and say, okay, you actually took, a detailed response to this, and now everybody knows what that discussion was, and so it's been cured, so to speak. They do appreciate that. Okay. So the rules for these complaints is that it must be in writing on this Attorney General form filed with the public body within 30 days of the alleged violation. So, for example, if someone says that in July, the board approved some minutes, but they didn't do it in time. They didn't do it within their next 3 meetings. They did it, a couple of months late. Strictly speaking, that was a matter of public record in July. And so a complaint that comes in now is well beyond the 30 days. And strictly speaking, the board is not required to respond to that. Often I'll recommend, well, why don't you just do, at least a 2-line response saying, we're not required. This was filed too late, and we're going to keep trying to approve all our minutes on time. But it's not going to be found to be a violation by the Attorney General. So your response goes out. Sometimes the complaining party is not happy with the response. They don't agree with it. They can go to the Division of Open Government and say, I'm not satisfied with this. I would like your office to look at this and tell me whether you think it's a violation. So we deal with these all the time. That office might contact, your board's office and look for documents or minutes or something, and they may just have some questions about what happened at the meeting. The statute does give the Attorney General a broad range of enforcement options. Most of these don't come up, or they're extremely rare. One of them is to compel compliance with the open meeting law. They will often say, we find that you did violate this provision. We're not going to take any other action, but you're on notice now, so don't do this again. They can require a board go to a training session, which can be either ones that they put on or even something like this. They may, if it concerned minutes, the Attorney General might say, yeah, those minutes aren't sufficient enough. You don't have enough detail. So, go back and do as best you can with the records you have and make sufficient minutes. The AG can order to nullify an action that was taken by a board if the open meeting law violation was serious enough. I frankly haven't even seen that happen, but it is in the statute. We have seen occasionally a fine issued of up to $1,000. That's if the Attorney General kind of holds a kind of mini hearing on it, or the Division of Open Government, I should say, and finds that this was an intentional violation. In other words, the board knew they messed up under the requirements and went ahead anyway. And that's happened rarely, but they do have that authority. So if the public body gets one of these penalties and thinks it's wrong, the law says you can go to Superior Court and challenge it. If the Attorney General thinks that a board is being a serial violator and is not listening to what they're being told, the Attorney General has standing to go to Superior Court and file a complaint. And 3 registered voters of the town can also do the same thing. This, again, is extremely rare, if ever. And the main reason is that if these voters think the board has violated the open meeting law, they file a complaint and the board has to respond to them. And that's free. Going to court is not free at all. But the law does provide for that. Okay. Just briefly on these, I mentioned the state Supreme Court case, which came out. Barron was the name of the plaintiff earlier this year. This Natick School Committee case was similar, very similar facts, but it only went as far as Superior Court, where there was a public comment period and somebody got up and was saying very, insulting, kind of inflammatory things about the school department, and the chair shut them down. The court said, you can't do that, free speech. The Swansea case had to do with of posting things which don't fit, neatly on a 1 or 2 page agenda. There should be some way, let's say if the subject is a list, or the board is saying, review and renew alcohol and common victual licenses for 2024. It can't just say that. There has to be some way where a list can be found, whether that's on the website, whether it's attached to the back of the meeting notice or what have you. You need to find some way where that's available. And the Bolter and Wayland case was the selectmen were getting ready to do an annual evaluation of the town administrator. The chair circulated a form to all the members. The members filled them out, emailed them back to the chair, copying each other on it. Clearly, this contained nothing but opinions of the board members. And the AG said, or the court said, that's a violation. You were exchanging opinions about something before you that the public, wasn't privy to. So you either have to wait to exchange these things during a public meeting, so at least the board can now hear what's being talked about. I'm sorry, the public can hear what's being talked about, or you have to make them publicly available beforehand on the website. So just another thing to keep in mind. This goes back again to and intentionally or unintentionally exchanging opinions outside of a meeting. Okay.
Brian,
We got a
you
couple of
have
hands up. Sorry.
Thank you. Denise and then Erica.
Hi, Brian. Specifically, so I understand that I followed the court case where the person was quite insulting. So let's hypothetical. I'm the chair. Well, I am the chair of the finance committee, and someone calls me something really insulting. I have to listen to it?
Well, the short answer is yes. We talked about this a little bit in last night's session. If somebody is not only just being obnoxious, but they are literally interrupting the meeting, preventing you from going forward or shouting or something, you might want to try to take a 10-minute recess. If it's really bad, maybe you can get a police officer to lead him out. But you're going to need to be prepared to say, you know, this wasn't just because this person was calling me names or swearing at me. It was because he was preventing the meeting from taking place at all. So, but yeah, unfortunately, the short answer, this case from this year, the SJC literally said people have a right to be rude. So.
And
that's,
I honestly, and I don't have a right to not listen to it. I mean, if someone's calling me every name under me personally, I'm being personally insulted. I'm not talking about
Yeah.
insulting the board or just being,
Right.
you know, that was the
Right.
most stupid thing the finance committee has ever done, blah, blah, blah. But me personally I have to let them abuse me.
I would say that it doesn't cross the line to say, you know, listen, this is disrupting the meeting. I'm gonna take a 10-minute recess. You know, why don't you come talk to me? Tell me what your problem was with me, and we stop interrupting this meeting. That might be one way to approach it. That way you're
Okay.
not telling them, shut up and leave. You
Mhm.
know what I mean? But you are hopefully rescuing the rest of your meeting as well. So that's probably my best advice on that point.
All right. Thanks, Brian.
Sorry. Erica?
Thanks, Brian. And I wasn't going to say this, but Denise, the MMA has some really good webinars on that case, and about de-escalating public discourse and what the new rules are. So we can share those around. My point, I just wanted to note that, Brian, when you were talking about how you have to be very specific about the sufficiency of the meeting notices, I know for the select board, when we do like annual liquor licenses or annual common victualler licenses, we actually now say, you know, please see exhibit A or B or C, and we attach the list to the
Yeah.
actual posting.
Yeah, that takes care of it. One of the things that I sent Maureen, which if she hasn't already, she can circulate, is a response from the Attorney General's office saying, you know, if you've got a whole list of things or appointments to committees for next year, you can't just say, you know, approve these licenses or make these appointments. You have to have a list that people can take a look at. So that's good. That takes care of that issue. I guess Abigail, you're up.
Oh, hi. I have a couple of questions, but I don't want to take up too much time. My first one was, who has to recuse? We've been told, that if you have a financial interest, you should recuse from, being on a board's decision. What is your feeling on that? Who has to recuse?
Well, that's actually part of the conflict of interest law, which is I'm going to get to in a minute. But yeah, that is in the statute. You can't, as an official, you can't participate in a particular matter in which you or your family or your business has a financial interest. And so the short answer again is yes, you can't participate in that. You got to kind of walk away from the table.
Right. Okay,
okay.
that's, yeah.
But I will talk more about that in the next set of slides.
Let me see if this one is more appropriate for now. As a board member, can one recuse on a particular topic or application and talk as a neighbor or a citizen? If you understand my.
Yes, you can do that. Because let's say it involves your next door neighbor, and arguably, well, the Ethics Commission says we're going to presume that you have financial interest in that if it's something that affects property that abuts you. So yeah, you don't want to sit at the table and talk about that, but you can go in the audience. They do say, you know, you really literally should leave the table and be on record that you're not part of this decision. But on the other hand, it's an open meeting. You're a citizen. You can express your opinion. So you can, you know, go to the back of the room and ask to be called on and make your comment, as long as you don't, you know, vote at the end. So I'd say that is something you can do.
Okay, that's a great easy answer. Thank you for that.
Okay.
This is a kind of a sticky one, and it's about if you're on a board and you don't agree with your board, but you're in an appeal, can you talk against your board in an appeal?
You mean like in a court appeal?
Yeah, like an
Mm.
court appeal, like you have a difference of opinion on how your board voted. Are you
Well-
able to still talk on that subject against how the board voted, or are you not allowed?
Well, I guess it depends a little on what the context is. Let's say the board makes a decision and it was a 3-2 vote and it
Right,
gets appealed.
Yeah.
You know, our office is going to be representing that board and defending their decision. So which would only be the 3, because that was the official decision. You know, it doesn't necessarily mean that there's kind of a gag order against the other 2. And you could still participate in the executive session talking about that court case, even though you voted against the board's decision. So I think, I don't
So
know,
you-
is that?
it's a more democratic answer that someone
Yeah.
would be able to voice their opinion even if you were going against your board.
Yeah, yeah. Yeah,
I would think
I'd
that
say
would-
so.
Okay,
Mhm.
thank you very much.
Okay, Jeremy? Got your hand up?
Yes, I just was wanted to follow up on Denise's comment. It strikes me that someone has the right to be rude, but if they stray from talking about the issues and they're doing a personal attack on somebody, doesn't that stray into some sort of defamation or libel issue? And at that
it-
point, one can close them down?
It's, that falls in the gray area which this court case has created. You know, I mean, you are, the bar for defaming somebody is higher if you're a public official. I mean, that's kind of a very general statement. I mean, certainly somebody can cross the line, and it's good to, you know, as sort of your policy, say, you know, okay, we're going to open this matter up to public comment. You know, please try to keep your remarks to this matter and not to, you know, other things. But you know, this right to be rude was kind of a, you know, caught us off guard, and you know, boards have to deal with it. So, you know, if you let one person say, this is really important and I'm glad the board is talking about it and this is for the benefit of the town, and the next person gets up and says, this is ridiculous, you know, the board members, you're all idiots for even thinking this is a good idea. If that's what's being talked about, this case seems to say, no, you can't shut that down. Unless perhaps it gets to the point where they're preventing the meeting from going forward. And then I know Erica mentioned some de-escalation techniques that the MMA has sent around. It might be best to use one of those, such as taking a break and try to kind of diffuse the situation.
I got it.
Okay,
Thanks.
Brian, I just wanted to note that I put the link for that MMA presentation in the chat, so people can
Okay.
click on that link if they're interested.
great, thank you. I think we can go to the next slide, Maureen. Oh, okay. So this is almost to the end of the open meeting law. As you know, in 2020 and 21, with the COVID pandemic that was on, a lot of special laws were put in place to allow boards to hold things totally remote. You know, it kind of continued. It made some of these deadlines, you know, not as strict. Right now, the legislature decided to leave these in place until the end of March of 25. So that's another year and a half. So a board can certainly hold a meeting at a at a, room in town hall, just like the old times. You can do that and make it not, you can have, so the board is in the room and the public is not, as long as there's an adequate alternative means of public access. Something like Zoom is the kind of most common example of that. And public body members can continue to participate remotely. The regular open meeting law before 2020 says if a member is participating remotely, there has to be at least a quorum of the members physically in the room. Right now, that's not the case. So you can do the whole thing remotely if you want. You're not required to. Most boards are now back to the way the things used to be. And that is still the case. If you want if you want to make it public in a particular room and say that's where the meeting's going to be, that is fine. You actually don't need to provide some other kind of access. Okay. So this adequate access is supposed to be basically real time. If there's a time lag up to 20 seconds, Attorney General says that's okay. But if it's longer than that, that kind of is starting to defeat the purpose. If a technical problem arises, for some reason the Zoom link is not working anymore, you should stop the discussion to try to fix it. If it goes on for more than 20 minutes and you can't do it, the AG says you really should shut down the meeting and, post it 48 hours and try again. They were asked, well, how about if we were able to still record the meeting and then we can post the recording on the website the next day? Attorney General says it's not good enough. That's not real-time access to the public. And there are other things, of course, than Zoom. It's still the kind of the most popular, but something that gives real-time access is required if you're going to not allow the public to be physically in the room. Okay. So if the meeting's being recorded, again, chair needs to make that statement. If there are members who are participating on that remote platform, all votes should be in roll call, even in an open session. Remote members should be identified so people know who they're looking at. I don't think this is really necessarily required, but the AG says, if you're a board member and you have a camera, it should be on so people can see you. That helps identify who the board members are. And if it's an executive session being held remotely, members who are remote are supposed to state that, I'm here, I can hear what's going on, there's nobody else in the room with me who's going to influence it. Or there is somebody here and I'd like the board to acknowledge and allow them to, participate. Okay. Hybrid meeting. Some of the boards I work with do this. For example, the select board is in the room that they typically meet in, but either they're the only ones there, or maybe they've invited in a department head to be there, but everyone else who wants to participate or watch is doing it on some kind of live stream. That is also specifically allowed for the next year and a half. They might want to invite in somebody who's applying for a license rather than have them on Zoom, but that's the board's choice. Again, this thing about if the live access crashes, you may have to stop. And the public, the point is the public has to be able to hear and follow along, even if they're not going to participate by speaking. They have to be able to listen as the meeting is going on. Okay. In person, again, you can hold it in person. Those kind of restrictions, health restrictions aren't in place anymore as mandatory. Just like pre-2020, if you hold a meeting and it's a really controversial thing, you should try to plan ahead so whoever might show up is going to be able to get in the room and listen. And the AG's office has said that the board can decide to hold a meeting and require masks. That doesn't go against any of the current regulations. Okay. That's the last one. So that's the open meeting law. I know that was a lot. The Division of Open Government through the Attorney General's website has a lot of good information and summaries and things. So you could always look there. And if you think of something later today or over the weekend or something and want to shoot me a quick question, I'll be happy to address that as well. But otherwise, we're going to move on to the conflict of interest law. I'll just say up front, the conflict law, which is governed by the State Ethics Commission, an independent state agency. There are pieces of it which are pretty obvious. You'd say, well, yeah, obviously I'm not allowed to do that in my public office, but there are some things which are less obvious. And so I try to emphasize those so you can avoid inadvertently, tripping over one of these things. So there's our disclaimer again. And I will say that the conflict law in particular, what the answer is going to be really depends on the specific facts. And so again, I'm giving a broad brush thing here. Okay. So the conflict law you can find in General Laws Chapter 268A. And the Ethics Commission has adopted regulations at 930 of the Code of Mass Regulations. And I'm going to refer to a few of those regulations as we go. So the sections that apply to all municipal employees, and I'll talk about what that definition means. Section 3 has to do with accepting something of value, which only came to you because of you hold this office or because of something you did in your office. Can you accept it? Can you accept it and file a disclosure? There's different rules. As Section 17 basically says, if you're a town employee or official, you shouldn't be compensated by a private party or act as their agent or representative in something which the town is a party or has an interest. It's kind of a dual, competing interests, perhaps. There are some exceptions where you can do that. Former employees refers to someone who was a town official or sat on a town board. Now they're off. Can they get involved in their private capacity now in something in which they participated when they were on that board or held that office? There's some limitations to that. Section 19 and 20 are the two that comes up most of the time. I mentioned 19 earlier. If you're a town official, you can't participate in something in which you or your family or your business has a financial interest. And the exceptions are pretty limited. Section 20 has to do with a financial interest in a contract with the town. I'll talk about that. And then the code of conduct, the last section, is kind of a catch-all. If you're in the clear on these previous statutes, but there are certain things which you're not allowed to do in your public office anyway. So I'll talk a little bit about each of these. So municipal employee, you can see, is defined very broadly. It's basically anyone who holds any kind of position with the town, whether you're an office, whether it's elected or appointed, you're an employee who gets paid, you'll sit on a board that does not get paid, you have a contract, maybe you're a civil engineer and you get hired to do something for the planning board. While that's going on, you are a, quote, municipal employee subject to the rest of the conflict law. It doesn't matter if you're part-time, seasonal, etc. There's only two things which the definition leaves out. That's on the next slide. And that is if it's a representative town meeting where, not all the voters get to come. It's elected representatives. They're not considered a municipal employee if that's the only position they have, or an elected charter commission. So it's, as you can see, the net is very big on who this law applies to. Okay. As I say, paid or unpaid, full, part-time, seasonal, and even a private contractor who has a contract with the town, they are most likely going to be roped into some of these restrictions. Special municipal employee, section 17 and 20 has some exceptions to the general prohibitions which apply. There are certain offices which the general laws have declared a special municipal employee, like members of a housing authority, that statute says they're special municipal employees. Otherwise, it has to have been designated by vote of the select board, and the position is either unpaid, like a, ZBA, Conservation Commission, or if it's a part-time position, it has to be compensated for no more than 800 hours per year. So that's like 15 hours a week, or maybe a seasonal position. And as I say, there are some of the restrictions are less stringent if they are designated as a special municipal employee. That designation applies until the select board votes to take it away. It's totally up to them. Okay. Another definition which is important, particularly in section 19, is immediate family. And so that includes, you, the public official or employee, your spouse, and each of your parents, children, brothers, and sisters. So, but if I'm the public official, my wife's brother, clearly part of the immediate family. My wife's cousin is not. That's too far out to be considered part of the immediate family. I might still want to be aware that there might be an appearance of favoritism if I'm dealing with my wife's cousin. There's a disclosure I can do to fix that, but it's not part of the immediate family. And disclosures, there are several of these sections that talk about filing a disclosure, either with your appointing authority or if you're elected with a town clerk. And the Ethics Commission has a lot of these forms on their website. You don't have to use them. Writing it out by hand and filing it is good too. But there are a lot of things which you need to file a disclosure about in order to avoid having a problem. Okay. So section 3 briefly says you can't accept a gift or anything of substantial value. Ethics Commission has determined that's $50 or more, which isn't a heck of a lot. If it was given to you for or because of any official acts performed or that may be performed under your official responsibility. Basically, you were given this or being offered this because of the office you hold. So there are some kind of lengthy regulations about this one. I'm not going to go through it all, but some gifts are not considered to be a Section 3 problem. Some are, some require disclosure. One example is if it's really unrelated to your office at all. Somebody, whether it's a member of the public or someone in town hall, gives you a birthday present. Well, they're giving it to you because you personally are having a birthday, not because of something you did in your official capacity. The ethics came out once with when places, things like Verizon, were offering these employee phone discount plans to the town. And ethics looked at that and said, well, is that a gift of substantial value because of your office? Well, yes, it is. But they ended up saying, if this is something that is offered to all town employees and it's something that Verizon does to private corporations, we will not consider this to be a Section 3 kind of problematic gift. Or you go to a conference of people who hold your same office and there's a raffle prize and you win. Well, you wouldn't have been at the conference if you didn't have a town office, but it's not really a gift. It was a random thing that came your way. So they say that's not a problem. Okay. So if somebody offers you, you hold a public office and you really helped somebody out with something they had to deal with the town with, and they want to give you, let's say, a bottle of wine and it's worth $30. Can you accept that? Well, you can decide whether you want to or not, whether you don't want to have that appearance hanging over you. But technically, if it's less than $50, you can disclose it. You do have to file a written disclosure about that with either your appointing authority or the town clerk. And I should note that these disclosures that are required or recommended under 268A are always public records, so anybody could, request copies of it. Okay. Some other ones that the Ethics Commission came up with that they don't have a problem with. Let's say as your position of DPW superintendent, you're getting ready to buy some big expensive piece of equipment, and the manufacturer says, well, why don't you come down to our facility in New York and take a look at it? and you can ask us questions and whatnot, you know, we'll pay your travel expenses to come down. That is a legitimate job related. It serves a public purpose because this is town equipment. And so you have to file a disclosure about getting this free trip, but it's not a violation of Section 3. And maybe if you're going to go talk at one of these kind of public official conferences, and so you get free admission, that is okay. Again, serves a legitimate public purpose. There's a bunch of these in 930 CMR. So, you know, you can always look there. Okay. Jump into Section 17. This is one, as I say, you're not supposed to get, if you hold a town position, you're not supposed to be paid by a private party or act as their agent or representative. If it's a matter in which the town is a party or has a direct and substantial interest. So as I say, it's supposed to avoid any potential divided allegiance. I'll use an attorney as an example, say I'm an attorney, I sit on the zoning board. I am prevented from representing a client in dealing with the town with anything to do with the town. However, if the ZBA are designated special municipal employees, I can actually represent a client in dealing with a different part of the town, but I can never go across the table and represent a client in front of the zoning board. So that's an example of how things apply less strictly to a special employee. Okay. Acting as an agent, this isn't defined in the statute, but the Ethics Commission reads it again pretty broadly. They read a lot of things pretty broadly. You know, clearly, if it's an attorney representing a client, that is a very formal agency relationship. And if you're in that relationship, you can't contact another town office on their behalf, or, you know, act as a liaison between the building department and your client. Providing documents itself might be a problem. Let's say you sit on a town board and you're a civil engineer, and a client asks you to prepare a plan, and you put your engineering stamp on it, and then that's all you're involved in. But then they go off and file it with an application before the planning board. The ethics says, well, that's acting as an agent for that private party, and clearly the town's involved, so that's a violation. So if you have one of those kind of jobs, you have to be very careful about where, you know, your work may end up. Okay. Also, let's see. Even speaking on behalf of a neighborhood group in front of, you know, a town board, even that, as informal as it is, you might be held to be acting as an agent. This doesn't apply if you're representing yourself, just if you're representing somebody else. And let's say you're in a neighborhood group who are concerned about something which is coming up for action before the town. You can certainly act behind the scenes, be part of putting together, you know, a pitch to the town, one way or the other on this matter. But, you know, have somebody else in that group be the one who gets up and does the talking, not you. But if you get paid for doing that, you know, Section 17 has prohibitions against that as well. Okay. This was a particular regulation because the Ethics Commission realized that this happens on kind of a regular basis. You have someone who's very passionate about, let's say, the town library or the senior center, and so they sit as a library trustee or a council on aging member, and they are also connected with the, you know, Friends of the Senior Center, or Friends of the Public Library, which is a private group. If you act as an agent for the private group in dealing with the town, all of a sudden you may not even realize it, but you have just violated Section 17. So the Ethics Commission said, if you are in a town board and that board sort of designates you to kind of be the liaison with this private group, that we will say that does not violate Section 17. It has to be sort of a, you know, open situation where your board has given you this designation, but they don't consider that to be a violation. And you can always advocate for yourself. For example, you may have a town position, but you want to apply for an abatement to try to reduce your property tax bill. That's okay. You're representing yourself. So even though you hold a town position, you can go to the assessors and do that. What you can't do is appear before the assessors to talk about, you know, your family members' abatement application. Okay. The section 19 and 20 are the ones that come up all the time. I deal with this statute a lot. So it says whether you're appointed or elected, and this one doesn't care if you're a special municipal employee. It says you may not participate officially in a particular matter in which you, your immediate family, or your private business or employer has a financial interest. And ethics said it doesn't matter if this is $20 or, you know, $10,000, or if it's positive or negative. Maybe you're participating in something which might reduce your property value. That's still a financial interest, they say, and you cannot participate in that. There is an exemption for appointed officials or employees. You can file a certain disclosure with your appointing authority, say, you know, I would like to participate in this. However, you know, my brother is one of the owners of this, or my private employer, you know, would benefit if the board votes yes on this, but I can act objectively and I would like to. Your appointing authority can consider that and sign off saying, this has been disclosed, but I feel the integrity of your service to the town is not going to be compromised if you participate in it. If they're willing to do that, then you can participate without violating section 19. This obviously does not apply to an elected official. Okay. So that's the gist of section 19. Like I say, it comes up more often than you might think, but it's pretty basic on what the things you can and can't do are. Section 20 is frankly the worst section to deal with. It says a municipal employee, which again is elected, appointed, etc., can't have a financial interest in a contract with the town unless you qualify for one of the specific exemptions in section 20. They've created some new ones by regulation as well. And so contract kind of means two different things. One might be maybe you have a private company and you'd like to sell some supplies to the school department. That's obviously a contract with the town. But it also applies if you have one position and a compensated position, another compensated position opens up and you'd like to apply for it and take it. That would also be a contract if you were hired for that. And so you'd have to make sure you qualify for one of these section 20 deals to be able to do it. Sue? Sue,
sorry.
Oh, there you are. Okay.
Sorry, my bad. I didn't mean to click that.
Oh, all right. So let's see. Oh, so yeah, section 20 has a lot of different exemptions. There are two that apply to special municipal employees. It's easier for them if you know, if it's in a different department of where they are and they file a disclosure and file it with the town clerk, very often that takes care of it. There's one that says if you are a town municipal employee and you want to take on a position as a part-time or call firefighter or, you know, police officer, EMS worker, you can do that and get paid for it, but there's a particular disclosure, and I believe the select board also have to vote to approve it, but they make that a little easier. You can, if there's a state housing subsidy program that the town's a part of and you qualify, you can take advantage of that. That's contract is not considered to pose a problem. There's some other ones which are even hard to read through, but they do come up sometimes. Okay. So as I say, there are some available to special municipal employees. If you're not a special, you're a quote regular employee. There is one under 20B, which sometimes can work. It does have about 9 different steps to it. So this second contract, the second position, would have to be with a different department from your regular position. It can only be given to you after public notice, whether it's, you used to say newspaper, now there may be something posted on the town website, for example. A written disclosure is filed with the town clerk. If it is for personal services versus selling some kind of goods, So like a second position with the town. The second one has to be outside the normal hours of your original position. You can't get paid for more than 500 hours a year. The head of the agency with this second position has to certify that this is a real job opening that we need filled. And the select board votes to approve your exemption. So it's a lot, but sometimes it's the only one that might work. Okay. Here's one established by regulation. Before about 10 years ago when they adopted this, if you, let's say you had a paid town position and there was an opening on the zoning board, which is unpaid, and they couldn't find anybody, but you're willing to get appointed, ethics used to say, well, you can take on the zoning board position because it's not compensated, so that doesn't trigger section 20. But now that you're on the zoning board, you need to meet an exemption in order to keep that original paid position that you had, which was kind of crazy, and it prevented people from, wanting to do the right thing and help out. So they adopted this regulation, which said if you have one town paid position and you take on one which is uncompensated, that's the end. You don't need to look back the other way anymore. They do say an uncompensated position has to mean just that. If it has a stipend, you can't just say, well, I just won't accept it. It's still a compensated position. But at least it's better than it used to be. Okay. So contract, again, it is very broad. If there's a financial interest involved in it, buying and selling property to the town gives rise to a contract. Surplus property, sometimes the town sort of auctions that off. You will want to make sure if you end up being the low bidder that you're not creating a problem there. Ethics did create an exemption saying that if a municipal employee is selling property to the town, that is not covered under section 20, but it does not apply the other way. Town employee buying, real property from the town. So that you'll have to look and see how section 20 is going to work and if you need to do something to get around the problem. And as I say, section 23 is kind of a catch-all. So these, the two that come up the most are 23B2, which is don't use or attempt to use your office to obtain for you or anyone else an unwarranted privilege of substantial value. There's the $50 again, not properly available to similarly situated individuals. So basically, don't use your office or your job title or inside information to try to gain some advantage that the person on the street wouldn't have that same thing. You're supposed to do what you do to serve the public in your office and not use it for personal gain, basically. Okay. And 23B3 is known as the appearance section. So 23B2 means you actually misused your office for some kind of private gain. This one says don't act in a manner which would cause a reasonable person having knowledge of the circumstances to conclude that you're acting with bias or favoritism or for other personal reasons. So even though you may be perfectly, innocent and doing this not to give somebody a favor, if the facts might lead someone to think that that's what's going on, that can violate this section. But it also says it's unreasonable to reach that conclusion if you have filed a written disclosure of the facts before taking that action. So very often I get questions of, is this a conflict of interest if I do this? Just as an example, I'm going to have to vote on granting this license. It's not my employer, it's not my family, but it's somebody who's been my best friend for 25 years, and it's kind of known around town that we are best friends. Is that a conflict of interest? And I would say, well, that doesn't trigger any of the other ones, but the fact that you're even having this thought kind of means you'd like not to get stuck by it looking like there's a conflict here. So you have two choices: either recuse yourself and don't act on it, or file this written disclosure explaining what your relationship is with this applicant. And if so, somebody can't complain later that you violated 23B3 because this disclosure is on file. So I say, better safe than sorry. Why don't you just fill out the disclosure and file it, and then you're safe. Okay. This is an example how certain things can kind of bleed over into the conflict law. In general, town officials or departments can be engaged in fundraising for one purpose or another. You know, the fire department may try to raise donations to buy new, safety equipment. And that's valid under the municipal finance laws. You have to handle them in a separate account. But Ethics Commission says you can't use any overt pressure. You say, you better make a donation, or, good luck on your next inspection. I mean, that one's kind of obvious. Town employees have to use objective standards and reaching out on any kind of fundraising efforts. And you're supposed to keep a list of names of, what parties you approached for this. And so that also kind of, as I say, can trigger this don't misuse your public office for some kind of, private gain. Okay, next one, Maureen. And also this advisory says, you must avoid inherently being coercive as well. So the overt one is kind of obvious, but let's say someone has I don't know, they've got a bid in on a big contract, or they're waiting to get some kind of license, and they get approached to make a donation. Well, if it's kind of common knowledge that they're waiting for this approval from the town, really counting on it, and they might think, if I say no to this request, is that going to look bad on the application I'm waiting for? You would just try to avoid those kind of situations, and know who you're talking to. Okay. Okay. I think this is the last slide. So, ethics says, other things under this section 23, using town resources for personal business. Let's say you need to, print off a bunch of things for this little cottage business that you have. Well, don't use the town's, copy paper and copiers. Don't use your, town email address to send off totally personal things. That's considered improperly using your office. Directing subordinates that serve under you to go do, go take care of something on your property or some other private interest. And the reason I put "don't you know who I am" was one of my favorite violations was a selectman in a town got pulled over for speeding or something in the town by the police, and said to the office, "Don't you know who I am? I appoint all of you people. I appoint your boss." Somebody filed a complaint about that. And indeed, the Ethics Commission said, well, talk about misusing your office. You're trying to throw your weight around. And, nobody else who gets pulled over for that was able to do that kind of thing. And that's a violation. And they assessed a fine against this selectman, who hopefully learned their lesson after that. Okay. Ethics, just like the AG's Division of Open Government, the Ethics Commission also has a lot of stuff on their website, a lot of good advisories. They've got a whole series of advisories on, how this law applies to building inspectors, how it applies to Board of Health members, and those are useful. And also, if you're being asked to do something and you're not sure whether it might be a violation or not, I mean, town council can help you with that. But you can also call the Ethics Commission's legal division. They have a series of attorneys in that office, and they take turns being attorney of the day. You can call in and leave a message and what your question is, and they're pretty good about getting back to you the same day. And you can talk it through, and they'll say, "Oh, that's a problem. Sorry, you really can't do that." Or it would violate Section 19, but you can, ask your appointing authority to approve it for you, and then you'll be fine. So it's very useful. Obviously, it doesn't cost anything. So it's a good resource. But the conflict law is very broad, and as you can see, you might end up accidentally violating something which it didn't even occur to you. So, it's good to be aware of at least what the general restrictions are here. I think that's it, Maureen. Yes, it is. So same thing, you know, if you think of something down the road and you have a question, feel free to, you know, give me a quick call or send me an email and I will try to help you out. Or the Ethics Commission is there to do the same thing. Other than that, that is the conclusion of today's training. I appreciate everyone's attention and good questions that were out there. And hopefully you'll find this useful. Now you can enjoy the rest of your Friday.
Thank you, Brian.
Okay. All right. Well, you're welcome. Good to see everyone. Thanks for putting this together, Maureen. And we will talk to you soon.
Very good. Have a good afternoon.
Okay.
Bye-bye.
Bye.